Greetings. I'm going to talk to you today about judicial neutrality. This is a key aspect when we're considering the UK judiciary and the Supreme Court, often muddled up with judicial independence, which is very different. And I've done another lecture on that, which I would advise you to also watch. But judicial neutrality, also referred to as judicial impartiality, basically means the impartial administration of justice. That is the idea that judges should not allow their personal or political opinions to influence their judgments. They should treat all of the people who come before them in court equally and without prejudice. So how is judicial neutrality achieved? Well, there's a number of mechanisms, if you like, in place that are supposed to guarantee that judicial neutrality is adhered to. First of all, judges are supposed to be anonymous. The Kilmore guidelines, as they're called, established in the 1950s, established that judges should not give media interviews. They should not comment on their rulings to the media or in the public. They should not be involved in politics. They can vote, but they cannot get involved in political campaigns or stand in elections, or even make their political views known. Secondly, they're supposed to provide, and by law they are bound to, provide legal justifications for their rulings. That is, they must demonstrate how their verdicts are reached on points of law, and this is to ensure that they, to try and minimize the role in which their own personal opinions or prejudices could play. They have to justify their rulings according to the law. And finally, judges, and of course the more senior, the more this is the case, have a very high level of training. So again, this is supposed to ensure that they follow protocol when reaching their judgments, and again, to kind of minimize the role that their own personal opinions, their own politics, their own prejudices could play in informing their judgments. So these are the mechanisms by which judicial neutrality is supposed to be maintained. The anonymity, the legal justification of their rulings, and the high level of training they receive. However, there has been in recent years in particular an increasing clamor, especially from the right-wing media, that judges are allowing supposed liberal and pro-European biases that they have to affect their judgments. So one piece of evidence that is pointed to support this argument is the factor-tame ruling of 1990, when the UK courts established that EU law takes precedence over UK law if there's a contradiction between the two. So other evidence of this, and other evidence of this supposed bias, is supposedly found in the 2016 Supreme Court ruling on Brexit, when judges ruled that Theresa May could not request Britain's withdrawal from the EU without first seeking parliamentary approval, and of course getting parliamentary approval. And then there are a whole string of rulings by the judges opposing executive and parliamentary measures that have been taken in the name of tackling terrorism. The Belmarsh case in 2004, for example, ruled that foreign terror suspects could not be detained indefinitely without charge. And in 2010, the court ruled that ministers did not have the power to order the assets of terror suspects to be frozen. This is an ultra vires ruling. All of these cases, critics argue, show that the judges have an inbuilt liberal bias, and in some cases pro-European bias, that is leading them to make these judgments. That these judges are based on their own political opinions rather than on a strict interpretation of the law. However, it's very hard to prove these accusations. In all cases, after all, the judges did give legal justifications for their rulings. Really, I would argue what the right-wing press is objecting to is precisely that judges are neutral. That is, they're applying the law rather than allowing the law to be overruled by right-wing prejudice. A more serious concern, however, about judicial neutrality emerges when we look at issues such as racial variations in sentencing. That is to say, people of different ethnic backgrounds being more or less likely to receive prison time for the exact same crime, depending on their ethnic background. Now, it's long been documented that the judiciary is dominated by a privileged elite of white, male, privately educated Oxbridge graduates. Indeed, the Supreme Court today, which is made up of 12 judges, comprises 10 of whom were privately educated. Bear in mind, across the population as a whole, only 7% of people are privately educated, but 10 of the 12 Supreme Court judges come from private schools. 10 of them went to Oxford or Cambridge University. 11 of the 12 are male, and all 12 of them are white. And there's evidence that this narrow social background of the judges is indeed influencing their judgments. For example, a study of 1 million court records carried out by The Guardian found that black offenders were 44% more likely than white offenders to be sentenced to prison for driving offences. They were 38% more likely to be imprisoned for public disorder or possession of a weapon, and they were 27% more likely to be imprisoned for drugs possession. The same study found that Asian offenders were 41% more likely to be sent to prison for drugs offences than their white counterparts, and 19% more likely to go to jail for shoplifting. We could also point to a possible class bias at work. For example, in a recent case of an Oxford student who stabbed her boyfriend, being spared a prison sentence on the grounds that the judge said he didn't want to damage her promising medical career. The implication, of course, is that had she been, for example, a cleaner or a shop assistant, he would have had no such sympathy and she would be in jail. To conclude then, judicial neutrality is a bit more difficult to achieve than judicial independence. Judicial independence simply means keeping judges free from external political pressures, that is, pressure from the government, from parliament, or perhaps from the media. But ensuring neutrality means judges have to be inoculated against, if you like, their own internal political pressure, if you like. That is, their own personal biases and prejudices, many of which they may well not even be aware that they have. So whilst it may be possible through sensible regulations such as the requirement to provide legal justifications for their rulings to ensure that the most blatantly political judgments can be avoided, studies like those carried out by The Guardian show that the influence of social background remains pervasive.